Hello friends, welcome to ePathshala. My name is Malvika Seth and I am an assistant professor at the O.P. Jindal Global University. I will be discussing the module titled Justiciability of Economic, Social and Cultural Rights in India. This module is being recorded on behalf of Professor Rehan Abiratne. This module will introduce students to the Constituent Assembly debates and constitutional provisions that address economic, social and cultural rights. It will also survey Indian Supreme Court case law on economic, social and cultural rights, noting how the rise of public interest litigation in the 1980s and 90s changed how these rights are implemented and enforced under the Constitution. The enforcement of economic, social and cultural rights in India has changed significantly over the years. The Constituent Assembly, which drafted the Constitution of India 1950, separated these rights for the most part from civil and political rights. Economic, social and cultural rights were not placed in Part 3, which deals with the fundamental rights, but in Part 4, which deals with directive principles of state policies. As a result, economic, social and cultural rights were not originally enforceable in courts. However, beginning in 1980s, the Indian Supreme Court issued a series of judgments in which it interpreted Article 21, the right to life and personal liberty, not only to protect against the arbitrary taking of life, but also to encompass a broader right to live with dignity. This brought various directive principles of state policy within the ambit of Article 21 and made them enforceable in court. The expected learning outcomes of the module are as follows. After completing this module, the students should know and understand, first, the Constituent Assembly debates and constitutional provisions on the economic, social and cultural rights. Second, the original judicial approach to economic, social and cultural rights. And third, the advent of public interest litigation and the shift in economic, social and cultural right interpretation and enforcement. The first part of the module discusses the economic, social and cultural rights in the Constitution of India. India gained independence from the British in 1947 and adopted its constitution in 1950 after more than 2 years of debate within its Constituent Assembly. Given the poverty and high degree of inequality in India, social and economic justice was a priority in the drafting of the Constitution. As Granville Austin has noted, the Indian Constitution is first and foremost a social document, as many of its provisions are directly aimed at furthering the goals of the social revolution. Yet, the question of whether to include socio-economic rights in the Constitution was a matter of debate within the Constituent Assembly. Some members favored including socio-economic provisions as justiciable rights, that is, rights that can be enforced in court. K.M. Munshi drafted the rights of workers and social rights, which included the right to a living wage and protections for women and children. Dr. B.R. Ambedkar, the chairman of the drafting committee, favored a social scheme to nationalize all major industries that would take effect 10 years after the Constitution was adopted. In the end, the members of the Constituent Assembly took a middle path. Following the Irish model, they did not include justiciable socio-economic rights in the Constitution, but instead set forth a detailed list of directive principles of state policy, that is DPSPs. These are non-binding guidelines intended to guide elected representatives towards improving socio-economic conditions. DPSPs are explicitly non-justiciable. Article 37 of the Constitution states that they shall not be enforceable by any court. One of the reasons directive principles are non-justiciable is that they represent aspirational long-term goals of the state that are not suited for judicial review. For example, Article 38 subclause 2 declares, the state shall in particular strive to minimize the inequalities in income, while Article 39 subclause 1 requires the state to direct its policy towards securing that the citizens, men and women, equally have the right to have an adequate means of livelihood. Part 3 of the Constitution, entitled The Fundamental Rights, includes inter alia the rights to life, liberty and equality that courts may enforce pursuant to Articles 32 and 226. DPSPs were placed in Part 4 and, as discussed above, were made explicitly non-justiciable. DPSPs are non-justiciable because they represent aspirational long-term goals of the state to be progressively realized. The Constitution sought to give elected representatives the flexibility to pursue these goals gradually and in light of resource constraints without having the courts to interfere in their enforcement. Some economic, social and cultural rights, however, are found both in Part 3 and Part 4 of the Indian Constitution. Take, for example, the right to education. Article 45 is a DPSP which provides, in quote, the state shall endeavour to provide within a period of 10 years from the commencement of this Constitution for free and compulsory education for all children until they complete the age of 14, quotes closed. Two fundamental rights in Part 3 also pertain to education. Article 29 states that no citizen may be denied admission into a state-run or state-funded educational institution on the grounds of religion, race, caste or language. Article 30 grants all minorities the right to establish and administer their own educational institutions, whether based on religion or language. Article 30 can also be viewed as a cultural right, as it grants minority groups the right to establish and administer their own educational institutions so that they may preserve their cultural heritage. Cultural rights provisions can also be found in Part 4 of the Constitution. For instance, Article 43 requires the state to ensure that all workers are able to fully enjoy the social and cultural opportunities. And Article 51A subclause F obligates all citizens of India to value and preserve composite culture and heritage of the nation. Thus, it would be an oversimplification to claim that all ECSRs were originally non-justiciable. Some aspects of these rights are protected in Part 3 of the Constitution and therefore can be protected in court. The second part of the module discusses the original approach to enforcing economic, social and cultural rights. Indian citizens may file writ petitions before the Supreme Court to obtain redress of violations of their fundamental rights in Part 3 of the Constitution. Article 32 empowers the Indian Supreme Court to grant a range of remedies. It provides that the court may issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, or certiorari, as it deems appropriate in a given case. Article 32 also states that citizens may move the Supreme Court for the enforcement of a right through appropriate proceedings. This grants the court some discretion to determine the procedure through which citizens may bring petitions alleging fundamental rights violations. In the court's early jurisprudence, the phrase appropriate proceedings was construed narrowly to permit only those individuals whose rights had been directly infringed to bring the suit. For instance, in Charanjit Lal versus Union of India, 1951, the court held that a shareholder of a company did not have the standing under Article 32 to petition the court to enforce a corporation's right to hold and dispose of property under Article 19, Subclause 1, Subclause F of the Constitution. The court noted that a corporation and its shareholders are separate entities and that therefore only the corporation could properly bring this claim. Similarly, in GC College Silchar versus Guwahati University 1973, petitioners challenged a resolution by a Guwahati University's academic council to retain English and introduce the native language, that is Assamese, as the languages of instruction. The petitioners claimed that this resolution violated their rights under Article 29 and 30, which allow minorities to enroll in any educational institution of their choice and preventing the state from discriminating against minorities in academic admissions respectively of the Constitution. Prior to this resolution, the university had used Bengali alongside English to help students understand the content of English language lectures. However, even though one petitioner was a Bengali speaking student, the court found that the impugned resolution does not presently affect the petitioners. Thus, it held that the petitioners lacked the standing to file this petition. The result of these early cases was to limit standing or locus standi under Article 32 to petitioners directly harmed by a disputed law. Only these individuals were permitted to petition the court to redress violations of the fundamental rights enshrined in Part 3 of the Constitution. In the early years of the Indian Republic, Article 21, which guarantees the right to life and personal liberty, was also construed narrowly. Drawing from US Supreme Court Justice Felix Frankfurter and the British tradition of judicial restraint, Article 21 was carefully drafted to exclude any mention of due process in favor of the phrase procedure established by law. This sought to avoid the substantive due process doctrine that emerged in the US and permitted the government to deprive citizens of life or liberty as long as it acted pursuant to a duly enacted law. Thus, Article 21 originally limited the infringements of life and personal liberty that had no legal basis to prevent the courts from inquiring into the substantive fairness of the law itself. The third part of the module discusses the concept of public interest litigation, popularly known as PIL, and the expansion of Article 21. In the early 1980s, the judiciary became much more accessible to the public as the courts began to accept cases that concerned the rights of large swaths of Indian population. In this period, the Supreme Court introduced important procedural and substantive innovations that greatly expanded its own jurisdiction and allowed economic, social, and cultural rights found in Part 4 of the Constitution to be enforced in court. The procedural innovations in this period created a new form of litigation commonly referred as the public interest litigation. The court's most significant innovation was to relax standing requirements under Article 32. Moving away from the traditional view of standing, where petitioners had to show direct harm by an impugned law, the court began to recognize standing for any member of the public who moved the court for relief on behalf of any person or determinate class of persons is by reason of poverty, helplessness, disability, or socially or economically disadvantaged position, who are unable to approach the court for relief. The chief architect of this procedural revolution was Justice P.N. Bhagwati. In a 1984 speech delivered at Columbia Law School, Justice Bhagwati set out his views on standing, making the case that procedural formalism inherited from Anglo-American jurisprudence did not suit the Indian context. He said, in quotes, "The main obstacle which deprived the poor and disadvantaged of effective access to justice was the traditional rule of standing. It effectively barred the doors of the courts to large masses of people," quotes closed. In response to criticism of the court's judicial activism, Justice Bhagwati argued that it was very much in the province of the judiciary to develop new remedies to tackle difficult social problems. In his words, unorthodox and unconventional remedies were needed to initiate affirmative action on the part of the state to ensure distributive justice to the deprived sections of the community. The case of Bandhua Mukti Morcha versus Union of India nicely illustrates the court's willingness to experiment with the new remedies. A 3-judge Supreme Court bench, led by Justice Bhagwati, initiated at a PIL in response to a letter they received from an NGO urging the court to end the practice of bonded labor. Instead of simply issuing a judgment declaring bonded labor unconstitutional, the court adopted a doctrine which is now known as continuing mandamus, which permitted it to postpone its final judgment so that it may periodically issue guidelines and interim orders to ensure that the government complies with the relevant constitutional provisions. The court also appointed 2 advocates and a doctor as special commissioners to investigate the living and working conditions of bonded laborers and report their findings to the court. In sum, the court in this case not only relaxed its standing requirements to allow an NGO to file a writ petition on behalf of the bonded laborers, but also expanded the scope of its authority to conduct its own fact-finding and to keep the litigation open so as to monitor compliance with its orders. In addition to these procedural innovations, the Supreme Court instituted an important substantive change in the law. It began to enforce the directive principles of state policy by reading them into the fundamental right to life enshrined in Article 21 of the Indian Constitution. Recall that Article 37 explicitly states that DPSPs shall not be enforceable by any court. However, the court led by Justice Bhagwati once again sidestepped Article 37 in the larger cause of promoting greater human dignity and distributive justice. In the case of Francis Correll Mullen versus Union of India 1981, the Supreme Court was asked to rule on a narrow question: whether a detainee held in preventive detention had the right to meet his lawyer and family. However, Justice Bhagwati took this as an opportunity to substantially enlarge the ambit of Article 21, which provides that no person shall be deprived of his life or personal liberty except in accordance with procedure established by law. Writing for the court, Justice Bhagwati declared that this right to life and personal liberty protects a broader right to live with human dignity. He went on to state, Article 21 cannot be restricted to mere animal existence. Rather, it must include the right to the basic necessities of life and also the right to carry on such functions and activities as constitute the bare minimum expression of human self. The court has since built on this judgment to enforce a number of new socio-economic rights within the right to live with human dignity. These include the rights to education, food, healthcare, shelter, and a decent livelihood. Overall, the court enjoys greater scope for judicial review following these developments for at least three reasons. First, by easing its standing requirements, the court has become more accessible to the Indian public. NGOs and other concerned citizens now regularly petition the court for redress of fundamental rights violations on behalf of large affected communities. Second, through a broad reading of the right to life under Article 21, the court now recognizes and enforces a range of socio-economic rights that were originally thought to be non-justiciable. And third, by keeping cases open and inventing novel remedies in cases dealing with socio-economic justice, the courts now actively monitor government compliance with its orders. All told, the Indian Supreme Court is a significant policy-making institution today. To conclude, let's recap important points of the module. India has come a long way with respect to the enforcement of economic, social, and cultural rights. In 1950, when the Constitution was adopted, after more than 2 years of debate, economic, social, and cultural rights were placed in Part 4 of the Constitution as directive principles of state policy. They were separated from the fundamental rights contained in Part 3 of the Constitution, which included mostly civil and political rights, with a few notable exceptions, for example, Articles 29 and 30. While fundamental rights were made to be justiciable under Article 32, Article 37 of the Constitution explicitly prohibited judicial enforcement of DPSPs. Moreover, Article 32, which allows the Supreme Court to grant various writs to enforce fundamental rights through appropriate proceedings, was read narrowly in the early years of the Indian Republic. The court interpreted this phrase to permit only those petitioners who had been directly affected by an impugned law to have standing. Article 21, the right to life and liberty, was also read narrowly as the Constituent Assembly had intended to apply only to violations that had no basis in law. Courts could not adjudicate on the substantive fairness of existing laws. In the 1980s, the Supreme Court's interpretation of both these provisions would change substantially. It relaxed its standing requirements to allow any member of the public to move the court for relief on behalf of disadvantaged persons who could not file petitions themselves. The court also took a greater role in fact-finding by appointing special commissioners in some cases and in monitoring government compliance with its orders. It adopted a procedural innovation known as continuing mandamus, which permitted it to postpone its final judgment so that it could periodically issue guidelines and interim orders. The court also broadened the scope of Article 21 to protect the right to live with dignity. This brought various DPSPs within the ambit of Article 21, including the rights to food, education, shelter, and a decent livelihood. The result of all these changes is that the Indian judiciary, particularly the Supreme Court, has vastly increased its power and jurisdiction. Today, it is not just a significant legal institution, but an important policy-making institution as well. With this discussion, I hope you have been able to understand the trajectory of the economic, social, and cultural rights in India with respect to justiciability. For further learning, you are requested to refer to the e-text and self-assessment resources. Thank you.